Well, Nandipha Magudumana will hear her fate today. She wants her deportation from Tanzania and her arrest declared unlawful. Now, the High Court in Bloemfontein will rule on her urgent application today, but Magudumana argues her return was an extradition disguised as a deportation. However, Home Affairs says everything done was above board. And our senior reporter, eNCA Silindelo Masikane, joins us now to look ahead at today's judgment. Good morning to you, Slee. I mean, today is, of course, a judgment hoped will be delivered, but we heard extensively from Nandipha Magudumana arguing that deportation was rather unlawful. Actually, it was more of an extradition disguised as a deportation.
That's her argument brought forward by her legal team in her papers. And of course, we heard those arguments last week here in the Free State High Court. We spent about 5 hours or so ventilating what's being said in her papers, as well as, of course, the response from the state. We had lawyers representing Home Affairs, the NPA, as well as the South African Police Services. We are expecting judgment just after 10 a.m. this morning, and we've been getting some analysis from legal and immigration experts throughout the morning to see just what are the chances that Dr. Nandipha will be walking out of the Kroonstad prison today as a free woman. But to just unpack this some more for us, we are joined by Mr. Riaz Hanmarie. Thank you so much for your time this morning. You've had an opportunity to see the papers. You've also heard what was heard in the arguments last week. Did Dr. Nandipha's legal team present a strong case in terms of what they are alleging happened in Tanzania, or did we see the state actually saying everything was above board and showing the court that it was?
Good morning, ma'am. Thank you again for having me. Very interesting question once again. I think we must just start again from the beginning. On the 19th of May, an urgent application is lodged by Dr. Nandipha. There's no timelines attached to the application. However, it's brought on an urgent basis. We know then that the sixth respondent gets added. Papers are then filed on behalf of the respondents, and there's replying affidavits, and the matter was set down for Thursday. It's interesting, the arguments placed forward by the applicant through her legal team. One of constitutionality is raised, certainly, in that they are submitting that the two governments colluded. And in that process of collusion, as the applicants say, it was actually a disguised extradition and not a deportation. And then on the other side, you are hearing from the respondents, that's respondents 1, 2, and 3, as well as respondent 6 specifically, that this is not the case. Things need to be read within context of what is contained in the replying affidavits. The topic of urgency from the side of the applicant, they are standing by the fact that it's dealing with the liberty of an individual. Because of collusion, they saying this matter is urgent, there's somebody's liberty involved. The collusion has led to unlawful conduct, and in that sense, the whole process that followed thereafter was unlawful. The respondents are just disputing this, and they're saying that everything's got to be read within the context of what transpired. We were dealing with fugitives. The urgency, the matter is not an urgent matter. And they base this argument, especially the advocate for respondents 1, 2, and 3, on the fact that the applicant brought this application after some period of time and not immediately once she was arrested. And that's what you see playing out here now. So it's going to be very interesting to hear what the judge has decided in this matter. It is definitely a question raised regarding unconstitutional conduct. The submission from the applicant is that the South African government officials, whoever they may be, went above and beyond what powers they actually have in terms of the Constitution, and because of that, the conduct is unconstitutional. And this is a matter that it's very interesting to see what's going to come out in the judgment. That's the bottom line. I think a lot of us are waiting for this judgment to be delivered. One of the things that does stand out in my mind is, and it's very positive, from the side of the judiciary, that the Honourable Judge has decided on Thursday, after arguments were placed, that he is not waiting for an extended period of time, and in fact placed the matter till today, Monday, for judgment to be delivered. It can be argued that in the mind of the presiding officer already. Maybe he sees something that a question that urgently needs to be answered. And at the end of the day, we are dealing with an individual's liberty, and the allegation that's made is that the apprehension, abduction and arrest is unlawful. And that's what we're looking at.
Let's talk then that perhaps she does get what she is asking for. She could walk out of Kroonstad prison today. She could be in just a matter of hours a free woman. What then happens then? Can the state appeal? Will that stall her perhaps leaving the prison facility? And does the NPA then have to recharge her as well?
Look, definitely the safety nets that have been created within the judicial system leaves room open for any process to be appealed and questioned at a higher level. However, at the end of the day, I think what we should not distract from and get away from through the application that's before court is that there's alleged criminal conduct from the state side towards the applicant. So that she doesn't get away from the alleged conduct, in my view. So I still stand by what I placed in a previous interview, that once she walks out of court, if the decision goes in her favor, it is still the state's prerogative to decide whether they want to prosecute her and reinstitute proceedings against her. A warrant of arrest can be requested and authorized, and she could be rearrested, in my view.
Then let's talk about the fact that this judgment is very important in terms of determining the state's conduct or members of the state in terms of immigration when this unfolded. The state would not want to see a judgment in the favor of Dr. Nandipha, because it surely would be an embarrassment in terms of how they conducted themselves or how this process unfolded.
Yes, definitely so. However, what we are hearing from arguments placed on record on Thursday last week is that due processes were followed. The decision to deport was taken by the Tanzanian authority and not by South African authorities. The conditions placed on the deportation was done so by Tanzanian authorities as well. And the state is basically precluding themselves from any of that decision making. However, they do open up and say that there was some sort of an agreement between the two states. However, it was not to do with the decision of deportation and not to do with the conditions placed on the South African government by Tanzania on how the deportation was to take place. And that's what we saw, or that's what we've heard, and that's what I understand from the arguments placed on record in court on Thursday last week.
Yeah. So at this point, 50-50. We don't know. It could go either way.
Yes, like I say, the judgment is going to be an interesting one. There's a constitutional issue raised, so important questions, important points were made by both the applicant and the respondent. So it's very interesting. It's really interesting to wait for this judgment to come out.
Thank you so much.
Pleasure.
All right, that is Mr. Riaz Hanwari inside the Free State High Court, where in less than an hour we will be hearing from the judge in terms of his decision on whether Dr. Nandipha will walk or whether she remains behind bars.